It's to you. Kev Gills, I got you on me. Yeah, man. Welcome to the U, have a seat. The only professor applying pressure when he teach. Big cloud in these YouTube streets. I cheat like Wiz Khalid. Call it in if you gon' speak. Press 1 when you're checking in. I got the merch, cop a coffee, a kush shirt. Support the brand if you support the man. With the spirit of Steve Coakley, they can't hold me. Back them down and fade away on them like I'm COVID. Only straight shooter on this computer. Who else you know gon' bring it to your real truth? Hallelujah. More haters, more moderators. Get yourself timed out for making outlandish statements. Yeah, ain't no playing. Bungalow 54 is where you go with the herd. I got no patience. Either for God or you love Satan. It's reclassification over entertainment. It's to you. Everybody wanna have a school, but it's for you. Care less what a hater say you do. It's for you. Press 1 if you support, if you don't press 2. It's for you. Teach nothing over here but the living truth. It's for you. Press 1, press 1, press 1, press 1. Press 1, press 1, press 1, press 1. Press 1, press 1, press 1, press 1. Press 1, press 1, press 1, press 1.
Then he goes into charters of incorporation, franchises over public rivers, etc., etc. Now then he goes into descent, okay, and he says that the king of England we're discussing is a natural person on whom the crown descends by hereditary right as real estate does. This here is to come to us by descent and distribution. Okay, it descends upon the heir. You don't choose it. It just comes to you. It's yours. It descends like I drop it on you. It falls upon you. Devolves. We got to try to keep this simple. On page 56, Mr. Baldwin says, in other respects, the great features of both governments are the same. Both established by the people of the estates, E-S-T-A-T-E-S, of one, the states of the other. Each state or estate represented by their representatives in distinct bodies. Okay. Estates and state. Could the state of California be the estate of California?
Sure. Yeah.
Absolutely. Now we are going to stop and we're going to look for a definition of a state. A state, in Noah Webster's Dictionary of 1829, number 1, in a general sense, fixedness, a fixed condition, now generally written and pronounced S-T-A-T-E. And number 6, the general business or interest of government, hence a political body, a commonwealth, a republic. But in this sense, we now use S-T-A-T-E. So here we have 13 colonies who are going to be, who are 13 estates, creating a document of estates for the people of the estates. And when I say the word state from now on, it is going to mean to you estate, even if it's a capital S as compared to a small s, because there are separate estates. In reality, I perceive the capital S state to be a corporate function in Mort, Maine. Perceived, Oh, now we can go back. Okay. Okay, page 58, we go into the estates again. And Mr. Baldwin he goes into the estates of England, who they were, what their function was. And down at the marked section, the lords represented the two estates of the nobility and clergy. Okay, page 58. They sat in their own right, representing themselves and property as two estates or states of the nation or realm, wholly distinct from the third estate or state. That estate was the whole body of the people, represented in the convention of the commons. As there was no king, there could be no parliament or house of commons in any other capacity than in convention. Pardon me. This was at the time when the throne was abdicated. Life went on as normal. In England, the representatives still met. They still passed laws. They did everything they were supposed to do until the crown was placed upon another body, human entity. So at this point in our time, you can guarantee that our crown has been abdicated, or they are trying to abdicate the throne by getting rid of the sovereign state citizens as we know them and making everybody into a United States citizen who has no inherent power. The state citizen has it, not the United States citizen. So how do you gain the power? You get rid of the state citizen. This is genocide. This is absolute genocide. Now you can all say they're genociding me, and you know that they are. They have. Whoever they are. We're going to come to find out that you yourself is genociding yourself, or have genocided yourself. But you were forced to. To have this estate has either become illegal or it is null and void, according to law. Not moral law, but according to written law. Now, okay, do we all get what an estate is as far, superficially that we're discussing estates? Okay, and we all agree that we have an estate. Now we're going to find out what an estate is and what it looks like.
What page are you on, Don?
We're going to go to an introduction to the law of real property. This is an excellent little book. This is the little book. It's a little book. It's lovely. It's beautiful. Cornelius J. Moynihan. Now, what does an estate look like? What is an estate? Page 28, Chapter 2, Freehold estates. Sounds good to me. Freehold, holding it freely. It's free. And you will go to the underline and mark spots. Okay, okay. The word estate is a feudal origin and is derived from the Latin word status. Please send us your Social Security number so we might know your status. What your estate is. It speaks to us of time when land holding was inseparably connected with a man's political and personal status in the community. I say that it is still connected.
Very much so. Absolutely.
The next paragraph. The estate in fee simple is of potentially infinite duration. A life estate, or estate for years, is a finite duration. Life estate, freehold, fee simple. Okay? These are two different types of estates. We have the fee simple absolute is one type, life estate is another. On the other page, an estate in fee simple was and still is the largest estate known to law. It donates the maximum of legal ownership, the greatest possible aggregate of rights, powers, privileges, and immunities which a person may have in land. Now, when it comes to your rights, okay, when it says may have in land, all of your rights as a human being attached to the land or the estate you are in possession of. Okay? You might not own any land, but there is an estate, and your rights attach to that particular estate. This estate here was a fee simple absolute. Is a fee simple absolute. Okay. Littleton, in his famous treatise of tenures written in the 15th century, began his book by defining the estate thus: tenant in fee simple is he which hath lands or tenements to hold to him and his heirs forever. This definition is still valid. Now, do you notice right there where it says to hold to him and his heirs forever? This is very important. Just those words. Okay? To him and his heirs forever. On the next page, you will see the statute of uses brought into our line of thought and estate. And down at the bottom, you'll see that the law of real property of today is result of the application of both common law and equitable doctrines, and it was by means of this institution of uses that equity came into contact with the land law. Now we have, it's melding, okay, it's coming together. The statute of uses creating a trust now connects to the land, okay? It comes together. The beneficial enjoyment, like I said, the trust was for your use. A trust is for your use, your beneficial enjoyment. Your enjoyment, period. On page 219, let's skip that page. We'll go to the survey of law of property. Okay? Because this is where we're going to see the trust or the estate in the preamble. And I wish this was a little clearer copy for you. I must apologize. Down in the paragraph that I start underlining, now in law, when you have an object to convey, they don't use the person's name, okay? It's A, B, C, D, X, Y, Z represent a person, a human being. Black acre or white acre or green acre, some sort of acre, represents the object they are conveying. Okay? So if I say A conveys black acre to B, I'm A, you're B. This is Blackacre. Okay, now we know that we're talking about people, who I am, who you are, and what I convey. A conveys. So in the paragraph below, okay, we're conveying a fee simple absolute in this paragraph. It was an estate in fee simple, which is the largest estate known to law. It donates the maximum of legal ownership, the greatest possible aggregate of rights, privileges, and powers and immunities. Again, we have said we go to rights. Okay, we're conveying rights. Everything is in the estate. Privileges, powers, and immunities which a person may have in land. Again, it attaches to the land. It is not separate from. It is of potentially infinite duration. By the year 1250, the words "and his heirs" had become the only ones by which a fee simple could be conveyed. The word "be" and his heirs meant be in fee simple without any qualification whatsoever. But the words "be" in fee simple used in a deed would give "be" only a life estate. Okay? The words in the deed had to be "be and his heirs." The words "and his heirs" used in a deed were construed as words of limitation. Limitation? Say what? Wrong. That is, they describe the quantum or size of the estate transferred to be. The size. It wasn't a restriction. A limitation was not the restriction. It was the size of the estate. Strange as it may seem, the word limitation is contrary to what you think it should be. It's the size. The words of limitation indicate what is taken. Words of purchase indicate the grantees or persons who take it. We must be very clear. Okay, when you name somebody, now we are saying something about words of purchase. Okay, if I were to say A conveys Blackacre to B and his heirs and his son John, we just limited the size of the estate. We made it smaller. When you name the heir, it lessens it. That is why the heir is not mentioned in the preamble. We the people, A, convey Blackacre for a more perfect union, establish justice to ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty. This is Blackacre. This is the estate. It is the estate. A conveys Blackacre to B and his heirs. Right there is the estate. Do you see it? Do you get it? Mm-hmm. A conveys Blackacre to B and his heirs. It's sitting right there. Have you ever seen it? Did you ever see it before? No, you've never seen it before. It's beautiful, isn't it? It's an estate.
That's right.
It's an estate being conveyed. It is a fee simple absolute, a freehold. Who are the heirs? You can't name them. That's why they didn't put "we the people conveyed to ourselves and state citizens." You say, if they said that, it would have diminished not only our estate, but their estate. They were getting a life estate if they did that. They protected themselves, their estate. They protected our estate. It's of indefinite duration. It can last forever. infinitely, infinitely, right. It's a fee simple absolute. I saw this, and I thought, my God, that's beautiful. It's absolutely beautiful. It's right there in front of all of us, and we've never seen it. Never saw it. But why haven't we seen it? Could it be being kept from us? I never learned this in school. So there we have the fee simple absolute. Like I said, if they had named the heir, if they had done anything to signify who the heir was, it would have lessened the estate and it would have become a life estate. Now when you come to a life estate, you have problems because there are things that apply to it. You have responsibilities. To continue on with the fee simple, you'll notice on page 8 I have a few things underlined, such as if, now we're discussing the heirs or the parties of the estate, and if he dies intestate without any heirs, lineal or collateral, the property escheated to the overlord in feudal days, and now would escheat to the state. The estate, B's estate, will last only as long as he has heirs. Therefore, we have the 14th Amendment getting rid of the heirs. The estate lasts only as long as there are heirs. That is why we hear from these offside roots that the preamble or the Constitution is outdated and outmoded. Yes, because they have gotten rid of the heirs and it is not valid anymore. Why should we keep it around? Let's get rid of it. I heard by word of mouth, I don't keep up with these things, that one of the people who ran for presidency last time wanted to have a constitutional convention. Well, if the throne has been abdicated, a constitutional convention is proper, so that the throne can descend to something or someone else. Because we no longer need the Constitution as it is. It's outdated, isn't it? Mm. Well, you might think so, but I don't. On page 34, we come to a thing. You will notice that I have put some writing up at the top. It says restraint on alienation. Okay, case 40. A being, the fee simple owner of Blackacre, executed his deed to B as grantee in the following words. I hereby grant Blackacre to B and his heirs, but upon the express condition that it shall not be competent for B to dispose of or alienate said Blackacre for a period of 5 years after he receives the title to such property. Okay, so someone's attempting to pass a fee simple absolute here with a big but. But he can't do this or that or the other. So what type of estate does he really have? And down there you'll see the answer is C has a fee simple absolute in Blackacre. This question does not involve either a determinal fee simple or a fee simple on conditions subsequent, for no intention appears on the face of the deed. Here is a fee simple estate vested in B. The grantor then attempts to impose upon the grantee, B, a restraint on his power to alienate or dispose of the fee simple estate. Is such restraint valid? The answer is an unequivocal no. You have no power, no right to restrain a fee simple absolute in any way, shape, or form. You can put no conditions on it. Restraint on alienation. Pigeonhole that word. Because at this time, your Social Security number is a restraint on alienation to that estate. Okay, let's see.
Get the page you're on, Bonnie?
I am now on page 79. We're going into freehold estates still. An estate of freehold is an estate of indeterminate duration other than an estate at will or by sufferance. Again, it says so, indeterminate duration. This is what makes the Constitution infinite, to last for all ages, for all societies. Okay, this makes it immortal. It's beautiful. It is an immortal thing. It's there. Life estates. Now, I should have something on life estates in here. I know they're there. I hope we get to them. But we're going to throw something in on life estates. When you get to life estates, we have conditions on estates, okay? You can no longer waste. In a freehold estate, the fee simple absolute, the heir or the posterity, the person who has the estate, they can waste any portion of it they want. They can burn it, shred it, throw it away, give it away, anything they want. That's waste, okay? That owner can waste. But when it comes to a life estate, no. There is no wasting in life estates. No wasting in life estates. You're subject to duties, regulations, and laws. Wonder what kind of estate the 14th Amendment is. Here's a good one.
What page are you on, buddy?
We're on page 80. Some of the authorities, this is the third paragraph down, in an attempt to exactitude. I'm not always good at reading. Okay. Have employed the term fee simple absolute in such a case or in such a way as to set it off as a distinct legal concept. Totally new concept. Thus it has been stated that an estate in fee simple absolute means a perfect title. It is the entire and absolute interest and property in the land. Interest in the land. Your rights and duties to it are an interest in that. You have no duties, though, in a fee simple absolute, so your privileges, immunities, or everything is an interest in the estate. Difficult to pay. Page 81. Second sentence, there can be only one estate in fee simple to a particular tract of land. It is an estate of inheritance unlimited in duration, descendable to all the heirs of the owner alike to the remotest generations. And aside from the fact that it may be created so as to be defeasible and subject to executory limitations, or granted or devised subject to a condition subsequent, it is with respect to its duration and enjoyment as an interest in property clear of any qualification or condition. It has been defined as an estate of perpetuity confining an unlimited power of alienation, that or than which no person is capable of having a greater interest. And down at the bottom in the footnote, you will see that an estate which must be a fee simple is absolute, complete, and self-sufficient. An estate which must be nourished or kept alive by the grantee is obviously conditional or qualified or limited. This element of insecurity implicit in the grant impairs the totality and permanency of the estate, and such an estate is not a fee simple. Insecurity? Are you feeling insecurity with your estate? If we had our estate, we would not be feeling insecure. And insecurity is running rampant in this country amongst people. Heavy insecurities. Not trusting the other person, not trusting your brother, your sister, blaming everything on someone else. He did it. Republicans did it. No, the Democrats did it. No, the Latins did it. The Spanish did it. The Mexicans did it. The black people did it. The white people did it. The Koreans did it. Somebody else did it. They don't know who did it. They have absolutely no idea what's going on. Oh, let's see. Use possession. On page 83 in estates, it brings up the use and possession of property constitutes a gift. Let's see. Oh, we have the metaphysical concept of title. I like that word metaphysical. You know, for a long time I thought metaphysical meant ooh, you know, I didn't understand you know, until my good friend said metaphysical means thinking, thought process. Yeah, I like that word. I can understand thinking. It seems like that's all I ever do.
Well, if you quit, you're in trouble.
Yes, I believe so. I'm passing on to more pages. Okay, exception to the rule, reservation of the grantor. Here, we must understand exceptions. Okay, on page 90, The common law rule requiring words of inheritance in a conveyance to pass a fee simple was subject to many well-established exceptions. Thus, although it was usually held that words of inheritance were necessary to establish a fee in a grant containing a reservation in favor of the grantor, because a reservation is technically speaking a regrant of the property, no words of inheritance were necessary to establish an exception in fee simple in favor of the grantor, since an exception excluded from a conveyance that which would otherwise pass. Now, in the Constitution, the Fifth Amendment and certain things are exceptions. That power that was reserved to the people is an exception. Okay, now exceptions are very important when it comes to the estate. Okay, even though they put words of inheritance in here, okay, there are still found exceptions in the body of the Constitution outside of here. And we must find those exceptions at time. In the Fifth Amendment, you were reserved. This is, by the way, this is where liberty is in the Fifth Amendment. I had a couple pages of index on the Constitution, what is found where. Liberty is only found in the Fifth Amendment. That was interesting. The let's see, the blessings, where is it? There, nowhere in the Constitution is found domestic tranquility. There is no corporate power to administrate domestic tranquility. Yet it's in the preamble. It's part of the estate. It's supposed to exist. Obviously, we're not getting our domestic tranquility these days, but yet it is part of the estate and is not listed anywhere or even under any subject of the remainder of the Constitution. And liberty is only found in the Fifth Amendment. Now, the common defense and everything, all these other words, common defense, general welfare, that is enormous, and that is what they're administrating under the corporate mortmain jurisdiction. But several of these things just aren't being administrated under corporate function. It's kind of nice to know that they have something they can't administrate. So when I write to them, I'd like to have my domestic tranquility as part of the estate. Now, am I going too slow or too fast for most of you? Am I doing okay? All right. Oh, here's a good one. It's page 91, up at the top. It says, a grant to the government or a subdivision thereof as for the use of the United States forever contains sufficient words to vest an absolute fee simple. Now, I want you to just pigeonhole this idea of a grant to the government. Okay? In the United States, the common law rule requiring words of inheritance in a conveyance to pass a fee simple has never been applied to a conveyance to a trustee. The estate taken by a trustee is measured by the duties he is required to perform. Like the articles. And the exigencies of the trust, and not by the presence or absence of words of inheritance. But yet there they are, still there. Hence, in any particular grant to a trustee of a fee simple title is necessary to the performance of the trust, a fee simple passes even though the word heirs was not used in the conveyance. Contrary rule is obtained in England, however. So the articles are the duties of the trustees in this estate. Supposed to have gold and silver, all those good things, as money. That's a duty of the trustee. Very interesting. Gold and silver is the trust fund, the money, okay? If that's the money in this estate, what is a Federal Reserve note? Who is Federal Reserve note for?
14th Amendment.
Yeah, but that's a name. What's the thing?
It's a note.
We're looking for the things that the Constitution creates, not the name. 14th Amendment is another estate.
A foreign estate.
It's a separate estate. It is a life estate. It is an estate created under the estate. If I own a fee simple absolute big chunk of land and I wanted to maintain control of half of it or 3/4 of it and yet give maybe a quarter, sell a quarter, convey a quarter to someone else, but still get it back, I'd create a different estate, a life estate. You can have that estate until such and such time, then if you die or the conditions aren't met, I get it back. So I create another estate. That's what's happened. Another estate has been created. On page 207, the non-payment of taxes. Ooh, my. Now we're discussing a life tenant here. The mere refusal of the life tenant to pay taxes is not where there has been no actual sale for taxes, a ground for forfeiture of the life estate at the suit of the remainderman. Next underlined portion. Under some statutes, non-payment of taxes by a life tenant is regarded as committing waste, justifying forfeiture of his estate. Well, they're not going to have you forfeit your 14th Amendment estate, so they just put you in jail. You've committed waste, now you're subject to certain laws and conditions. Okay, as a 14th Amendment citizen, a life tenant, you're committing waste. That's against law. Even in old common law, it was against the law. So you see, we're at the common law, but yet we can't get to the common law. It's a paradox. The common law we want to get to is up here, way up here, but yet we're still at the effect of the common law because it's still hovering over us. They've just diminished our estates and we didn't know about it. Have not been informed. Full disclosure did not take place. If it did, certainly wasn't in my civics class. Now, under life estates, there are remainders. Okay, if I have a home in a life estate, I have to keep that home up in a good condition for the remainders, whoever buys it, whoever gets it after me. A frequently stated rule on page 220, a frequently stated rule is that the remainder must be created by the same instrument which creates the life estate. In the ancestor, in order for the rule of Shelley's case to apply. Now, the rule of Shelley's case is long and drawn out, but it's a highly important rule. Under this rule, a will and codicil are considered one and the same instrument. Okay? It has been stated that the limitation to the heirs may be made by a power of appointment contained in the same instrument. So the rule in Shelley's case is important, and I'm not going to go into it because we have right here quite a bit to go through without going into everything I read and learned. Now we're getting to the point of codicil and will. Okay, all of a sudden that has popped up into our little picture. We're not quite sure where it fits, or even if it does fit, it might belong to some other puzzle, so we're going to sit it over here temporarily. And now we come to American Jurisprudence 2D, which is volume 23, Dedication to Desertion and Non-Support. But we're going to be looking up deeds. We're going to find out what a deed is. You see, all of these things that are very important when we're looking at a trust, at a use, we have to look at what is a will, what is a trust, what is a deed, because deeds start coming in, and so do grants, and so that everything can come into proper perspective. Okay, so in deeds, what if I was wrong? What if this was a deed? Actually, it is. Okay, it is a trust. Everything, it all comes in. Up at the top here, grant is a synonym of conveyance. Do you remember back when Mr. Baldwin said it was a grant?
Let us know what page you're on.
82.
82.
82.
You missed that one. Remember Mr. Baldwin, the Justice Baldwin said that the Constitution was a grant? I do believe I read that. Right here in deeds, it says, grant is a synonym of conveyance. So now Blackacre has been conveyed. We now know it is a grant. Okay, and we find this under deeds, so obviously it is a trust deed. Doesn't have to be, but it is. This is very flexible, folks, unlike the law we know today. You know, we can take the word deed out and still say this is a trust without the word deed in there. Somebody brings a grant in, okay, it's a grant too. Yes, it's a trust, it's a deed. There are things that it is not, but there are many things that it is. Assignments. Section 5. The term assignment, which signifies the act by which one person transfers to another or causes to vest in another his right of property or interest therein, is sometimes used synonymously with grant. Again, so as to operate as a conveyance of the title to real property. But is ordinarily limited in its application to the transfer of intangible rights, including those in action and rights in or connected with property, as distinguished from the property itself. The term assignment, unlike the term deed, does not signify an instrument under seal, and at common law, if not under seal, it was not sufficient to pass legal title to real property. This document is a document under seal. Oh, then we have mention of wills down at the bottom of page 83. Under deeds in Amjor, we have wills. Okay? Whether an instrument is a deed or a will depends primarily on its operation and not on its form or manner of execution. The essential characteristic of a testamentary interest is that it operates only upon and by reason of the death of the maker. During his lifetime, it is ambulatory and revocable. Hence, the maker, by its execution parts with no right and divests himself of no oh God, this is getting different. Modicum. Modicum, how do you pronounce that word? Modicum? Modicum?
Modicum.
Modicum, okay, of his estate. I see, I'm not all-knowing. Even though you might think I am. After you know what I know, you're going to be a know-it-all too. It is fundamental, on the other hand, in order that an instrument may be operative as a deed, that it pass a present interest, although it is not necessary that the grantee take a present estate in the property conveyed accordingly. This is defining deeds and wills. on the operation. What was the primary operation of the Constitution? Besides, the Founding Fathers did not have testamentary capacity. The Statute of Will says that. But now we're segueing into, we're bringing in a little bit of will stuff because we're going to find out that the 14th Amendment creates a codicil. It is a codicil. The Founding Fathers are obviously dead, folks. They must be dead because everybody is taking under a codicil and looks like a will part of our document. It's segued. They must have died. We're going to find out that the 14th Amendment is you make an election to literally take under a will. Page 90. Deeds are traditionally regarded as consisting of a number of formal parts. The first of which is known as the premise. The premise of a deed, sometimes designated the caption, embrace matters preceding the habendum clause, such as the recitals of the grantor, intention and motives for his deed, the names, designations, and descriptions of the parties, etc., etc., the conditions expressed for the deed, words of grant, and the description of the property conveyed. Okay. Yeah, it defines it. It defines the property conveyed. The Constitution appears to have a habendum and all these things that are in deeds. Okay. We're looking at the construction of the instrument. This is how the Supreme Court looks at things. Words of grant on page 91. In order to transfer title, an instrument must contain apt words of grant, which manifest the grantor's intent to make a present conveyance of the land by his deed as distinguished from an intention to convey it at some future time. This showed no desire to do it in a future period of time. This was right then, there, and now.
Always now.
Always now. Oh, and down here in the bottom in section 20, although words of inheritance such as to the and his heirs and assigns forever are no longer necessary to pass a fee simple, the use of such words strengthens the reading of a deed to pass a fee simple title. Okay, so they strengthened even today, and not to amalgamum of lesser estates. Addendum, let's see, word covenant. Page 575. This comes from Amjor 2D again. You will find this under covenants. Covenants, conditions, etc. We have a covenant here. There is a covenant sitting right in here. Insure and secure. Those words are words of guarantee, insurance. The term covenant in its wide sense is used to indicate a contract, while the more specific application of the term imports an agreement deduced to writing and duly executed, whereby one or more of the parties named therein engages that a named act is already performed or is to be performed sometime in the future. A covenant may also call for the performance or non-performance of some specified duty, and may constitute an agreement to do or not to do a particular act. Is that in the Constitution?
Yes.
We have a covenant.
That's a moral obligation.
The term covenant is now used primarily in connection with promises, in conveyances or other instruments pertaining to real estate. You know it says now, but not then. Then this was a covenant. Again, a covenant at common law imports an instrument under seal.
If you notice, she keeps saying covenant because a covenant is a contract, and they're all under the contract. So their government is a covenant. Back to the film.
We have a covenant. Duration of covenant on the next page, 577 of Amjor. A covenant is therefore extinguished when the estate ceases. We are in imminent danger. Wouldn't you say so? This is still on the books. It's still in black and white. It has not openly been repealed. But I have a very sneaking suspicion that our government is going to take our estate away from us on or in black and white, or out of black and white, whatever way you want to say it. We are in imminent danger. We don't know what we have been arguing and fighting for until now. We can now look into the future. Okay, page 584. Let's see, second sentence. A covenant is viewed as implied in nature when its existence is inferred by legal construction from the use of certain words and phrases. Certain words and phrases. Insure and secure. These words are very important because they have a legal meaning. Every word in this document has a legal meaning when it comes to estates and when it comes to the construction of the written instrument itself. All the power of the entire Constitution is right here, not elsewhere. Because this created the corporate function. This created the trust function. This gave all of it power. Page 585, second paragraph, or let's see. Implied covenants can arise and will prevail only where there is no exception on the subject matter of the implied covenant. This is something you should look into at your leisure. Implied covenants still count, even if those words are implied, they count. On the next page, 592. Reflects upon the 14th Amendment, okay, the marked area. At common law, no person may claim the benefit of any covenant or condition except where he is a party or privy thereto. As a 14th Amendment citizen, you are not party or privy there to this estate, so therefore you cannot claim the covenant. You are barred from it. Are you getting to understand why we're having a little frustration in court? We're having a lot of distress. Page 594, section 23 of Covenants. The benefit of a covenant that runs with the land descends to the heirs, and they, as well as devisees and covenantees, are entitled to enforce such a covenant unless an evident intention is manifest to confine it to the covenantee. In the event a real covenant is breached, then it descends to the heirs. The latter may institute appropriate legal action to recover damages for such breach. However, if the covenant is personal, it remains with the covenantee or his executor or administrator. It does not descend to the heir. Try to go through this. On page 617 of Covenants and Condition, 20 Jur 2D. Section 45, breach of covenants generally. The broad rule is that a covenant or condition is broken by any single omission of duty or any act that contravenes the provisions of the agreement entered into between the parties. We have a breach of covenant. This is what we entered into, and it has now been broken by many acts of omission and duties toward this covenant. Not toward the 14th Amendment, but toward this specific one. Page 629, we're discussing paramount titles. This is a paramount title. Okay? 14th Amendment citizenship is in a state of inferior title. We're going to find that out. The mere existence of a paramount title which has never been asserted generally does not amount to a constructive eviction. We've got to assert these titles, okay, which will support an action for breach of a general covenant of warranty. Or, as the rule is sometimes stated, there can be no recovery in an action for breach of the covenant if the paramount title has not been hostilely asserted. So we're going to have to hostilely assert our paramount titles. Section 59, where the paramount title is in a governmental entity. Where the paramount outstanding title is in a government, this fact of itself constitutes such a constructive eviction as amounts to a breach of the covenant of warranty. Now, wasn't that nice of them to put that right there in black and white? So they have breached the covenant, they have breached the covenant of warranty, evicting us. We're just going to have to go back and assert our titles again. A grantee by warranty deed executed by a private person to lands owned by the United States cannot take possession without becoming a wrongdoer. Here's your allodial titles. And hence his right of action accrues immediately to recover for a breach of this warranty, and is not dependent on eviction or any future event, but under a statute providing that a warranty in actual possession of the premises conveyed shall have no right of action on a covenant of warranty until the party threatening the warranty's possession shall have commenced an action to obtain possession. We'll stop right there. Okay, so this is all about the breach of warranties and the covenants. Now, the next section is wills, but before I get to that, I want to read a definition out of Webster's 1828 dictionary of fee simple. Okay, because the question has arisen that fee was feudal, etc., and that it wasn't an allodial title. Okay. We'll skip some of this. Let's see. It's deduced from Saxon cattle, property, and fee, or primarily a loan of land, an estate in trust. Fee simple absolute, an estate in trust. Granted by a prince or lord to be held by the grantee on condition of personal service or other condition. I'm not too sure what the conditions are on the estate here that we have. And if the grantee or tenant failed to perform the conditions, the land reverted to the lord or donor, called the landlord or the landlord. In America, where lands are not generally held of a superior, a fee or fee simple is an estate in which the owner has the whole property without any condition annexed to the tenure. In the United States, an estate in fee or fee simple is what is called in English law an allodial estate, an estate held by a person in his own right and descendable to the heirs in general. So a fee simple absolute in the United States is allodial title. We're now going to discussion on wills, because like I said, I was looking to find out what was the Constitution, and the question had come up about the question had come up about what was a 1040? Was it a will? And I have to say, I don't believe so. But in researching it, I found a lot of interesting things on will, so we're going to go into that. Pardon me. Okay, page 275 of 79 Amjur 2D on wills. Okay, in there in the second sentence it says, by common law there were but two modes of acquiring title to real estate, namely by descent or by purchase. Where a person takes as heir at law, he takes by descent. But when he takes title to land by his own act or agreement, he is a purchaser. A little confused. Okay. Although in common application of the term, he may not have paid a consideration for it. A devisee who takes an estate different from what the law would cast upon him as heir is a purchaser. You can look at the 14th Amendment as being purchased. The estate is purchased because you take something that is other than what would be cast upon you by the law. This is the law. Okay? And as such, under the feudal system, was exempt from the restraints imposed upon heirs in their minority, such as wardships and right of marriage. Although the feudal system had passed away, hardly, I don't think so. Many distinctions of this character are still of recognized importance. It certainly is, because it hasn't passed away. It is still in existence, and I look at the world today, and we are living in feudal times. Accordingly, the doctrine of common law, even after the passage of enabling statutes, was that a will was in the nature of a conveyance, declaring the uses, purchase and not by descent. So if your father leaves you something in his will and you take it, you did not inherit it. You purchased it. Legally, you purchased it. You did not inherit. If he did not leave a will and you got his estate, then you inherited it. It fell upon you by descent and distribution. Otherwise, you purchased your estate. Just that simple. Can't get around it. Page 285. The animus testandi does not depend upon an understanding by the testator that he is making a will. Okay, the Founding Fathers created a trust, okay, and it was complete until after the Civil War. Then they start adding amendments. Now, if there is a trust, there's a possibility that the amendments could be construed as codicils to the will, or codicils of a will. It is a trust, and there are such things as wills or trusts with wills attached, or vice versa. Okay, so if we begin to look at the 14th Amendment as a codicil changes the intent of the testator or the trustor or whoever created it. 14th Amendment literally did change the intent of this right here. And they didn't have to know they were making a will, as this little paragraph says. The fact that the testator did not intend the language to operate as a codicil is immaterial on the question whether the instrument is in fact a codicil. Okay? So now we're going to start looking at the 14th Amendment as the codicil. Page 297 brings up the idea or thought of an instrument of dual character. Okay? Down toward the bottom it says, an instrument in writing may be a contract respecting property in one part and testamentary in another part in relation to other and distinct property. Here we have a definition and description of this estate as compared to the estate that we're going to see the 14th Amendment create. On page 314, again, section 55 there under wills, it says, property does not pass under a will by any natural right. There go your inherent rights, your vested rights, everything that comes into from the Magna Carta. Okay, so if you're a 14th Amendment citizen getting all your rights and privileges under a codicil, you do not have any natural rights. Your natural rights reside right here. You've given them all up for the privileges that the government has bestowed upon you. This is a state law. I didn't make this up. In these pages that you have, when you go through them at your leisure, you'll see that I have encircled or bracketed the footnotes. And a lot of these footnotes have some wonderful things to say or to look up that relate back to the paragraph. So study these intensely. Really get into it, because there's more here than what I'm giving you. And even that, what I'm giving you, there is a world more. I couldn't include everything in this lecture. Okay, but I figured this is the bare necessities for you to have and understand, and from here you can branch out. And if you get a letter from the whoever, the FTB, the State Board of Equalization, or the IRS, if you stay focused on your estate instead of them sucking you into the regulations that are established under the 14th Amendment for that particular estate, hopefully you will feel much better. Instead of arguing their argument, you will be arguing yours. At least I find that to be of value. If the testator intended to make an entire disposition of his property in substitution of that made by a prior will, he probably would have proceeded to make a new will rather than a codicil. Okay, so that applies to the Constitution. Second paragraph, while a codicil is a latter will in the broad sense, it is not an independent will, but purports by its form to be an addition to a prior will. Okay, so we're looking at the Constitution now and saying, okay, the original form was a prior will. Now we're adding the 14th Amendment as a codicil, changing the intent. Several clauses of the two instruments should, if possible, be harmonized so as to give effect to every portion of each instrument. Now we're separating things, okay? We're separating the two estates. They both have to coincide, truly, okay? Because the 14th Amendment is one state, but it comes from this estate. But in our minds, we have to separate them so that we can tell the difference. Okay, and in our separation, they still have to mesh perfectly. That's why there is no conflict of law. Okay, their estate and our estate are in complete agreement. Should be. On the next page, 651, section 532, where codicil is clearly inconsistent with will, where it is found that a will and the codicil thereto contain repugnant bequests of the two bequests, the one contained in the codicil shall stand. That's nauseating, isn't it? A codicil plainly inconsistent with provisions of the will operates to the extent of the inconsistency as a revocation of the will, even in the absence of any expressed words of revocation. Page 663, and this is where it's going to start becoming important to you, okay, to understand that the 14th Amendment as a codicil and what you have done. Section 1607, the doctrine of election. The doctrine of election in connection with testamentary instruments is the principle that one who is given a benefit under a will must choose between accepting such benefit and asserting some other claim he has against the testator's estate or against the property disposed by the will. One who elects to accept a benefit extended to him by a will is bound to give effect to all the provisions of the instrument and perform the burdens imposed upon him therein, including the renunciation of any inconsistent rights or claims. Yes, elections. We look at the 14th Amendment as a codicil. We have all made elections to take under the codicil or take under the will. Okay? Oops. I lost my thing.
You lost that a long time ago.
Okay. Be nice.
Gotta be edited.
Okay, let's go to page 677. About 677, section 1622. Manner and form of election, what constitutes? The question of the manner and form in which an election to take under or against a will must be made, or as it is sometimes phrased, of what constitutes such an election, is influenced to some extent by the applicability or inapplicability of a governing statute relating the particular kind of election election in question. If the election is one governed by statutory provisions relating to the manner or form in which it is to be made, the effect of such provisions must, of course, be considered. In the absence of an applicable statute, however, the view is generally taken that a testamentary election may be expressed or may be implied from the acts or conduct of the beneficiary on whom the election devolves. Second paragraph, there can be, it has been, excuse me guys, I don't mean to be this way. There can, it has been said, be no partial election to take against a will, but the election, when made, must be complete and final. This is saying that you cannot ride the fence. You can't use that Social Security number and have this. You can't have that bank account and have this, at least not at this time. You can't have all those wonderful benefits that are given to you by law and have this. Just can't do it. There's no riding the fence at this time. That's sad but true. Sad but true. Page 679. With respect to elections arising from matters in pays or implied from the acts or conduct of the beneficiary, it may be said that two things are necessary in order that the acts relied upon will amount to an election. Number one, the person alleged to have made an election must have been cognizant of his rights. I'm sorry, I don't mean to laugh. That is, he must have knowledge not only of the condition and event of the testator's estate, but also extent of the testator's estate, but also of his duty to elect between the two inconsistent rights. I don't believe anybody's ever informed me of that. Of course, they always tell me I made an election. And to having knowledge of his rights, he must have intended, as shown by clear and unequivocal acts, to make a choice. Haven't you done that? Mm-hmm. You've all done that. By your acts, you have seemed to made a clear choice. By your own acts. Of course, you weren't told your rights. You weren't disclosed anything about the estate. In order that the beneficiary's ignorance of his rights may avoid what otherwise could constitute a conclusive election, however, it must not have been culpable on the part of the beneficiary, and the misapprehension must be clearly shown. Okay, if you haven't been informed of your rights and you have had non-disclosures, you better start telling them about that, because your election really is no election. Okay, you might have made an election as it appears to them, but they did non-disclose to you. As a matter of fact, I don't believe I recall my civics class teaching me about this estate. And in my history class, I don't recall hearing about it either. Of course, I always heard that the government agents and the bureaucrats were, trustees or in their fiduciary capacity. You know, we've all heard that. Mm-hmm. Of course, they didn't explain that to me. And as an heir, I believe I have the right to know what they mean by their little words. They are trustees. Page 681. Section 1626, acceptance of money or property. In a large number of cases, the principle is is recognized, stated, or applied that a showing that the beneficiary faced with an election for or against a will has accepted, used, enjoyed, or entered upon, or remained in the possession of money. Yes, like Federal Reserve notes. Property. Or some other benefit, like unemployment, extended him by the will, tends to establish an election in favor of the will. The rule is, of course, subject to the qualification that acceptance of a benefit under a will, when made in ignorance of the beneficiary's rights, or under a misapprehension as to the condition of the testator's estate, such as bankruptcy, or other pertinent factual considerations, does not operate to constitute an election. Hallelujah, hallelujah. Okay, did you notice there? It said ignorance of your rights. Remember that little comment that ignorance of the law is no excuse? Well, ignorance of your rights is no election. How do you like those apples? I thought that was good. I like that. Moreover, the principle is subject to the further limitation that where the money or property was received or accepted in some other capacity than that of a testamentary beneficiary, well, maybe it's not. Maybe we're not testamentary beneficiaries. Maybe we're heirs. Okay? Or amounted to no more than what the beneficiary would have been entitled to, independently of the will. Such receipt or acceptance does not indicate the making of a binding election in favor of the will. We're entitled to it to begin with. As heirs, we are entitled to it. Those people who are taking under the will, who don't want to be heirs, but want to be beneficiaries of a different estate in order to be taken care of, because they're not capable of taking care of themselves and be independent, they may do so. I'm not going to stop them. I just want my freedom. I want my inheritance. I want my estate, that which was guaranteed to me. On the next page, you'll see some footnotes that are bracketed. Take a chance to read, or time to read those when you have a chance. Okay, section 1630. initiation or maintenance of judicial or administrative proceedings. Okay, while there is a general agreement that the unsuccessful assertion, and we've had plenty of them, in a judicial or administrative proceeding of a claim under or against the will does not amount to a conclusive election for or against it, the theory being that where such a claim is proved groundless, it is conclusively shown that the beneficiary was not in possession of two inconsistent rights. Oh, we're commingling. And hence was under no duty to make an election. There is no doubt that prosecution of or intervention in the judicial or administrative proceedings will, under many circumstances, be regarded as constituting an election to accept or renounce the provisions of a will. Okay, so what if you use the district court? Now you go, well, what does that mean? Okay, well, the district court is a tribunal established under the inferior estate of the 14th Amendment. And just because you've gone there doesn't constitute an election. Page 687, section 1634. As a general rule, an unconditional voluntary election to take under or against a will made with knowledge of the facts and of the rights of the person compelled to elect, and not induced by fraud or undue influence, may not be revoked or set aside.
I was told I had to get a Social Security number in order to work.
I believe that you've had a little bit of non-disclosure to it. Well, they're presuming that you were party to an inferior estate, one created for your benefit, because it is presumed that you are incompetent. Okay, next page, 1636. The prevailing rule is that an election to take under or against a will may be revoked or set aside where it was made through ignorance or mistake as to material facts affecting the rights of the party electing, and where the rights of the innocent third party will not be adversely affected by the revocation. I wonder who that might be. The revocability absent intervening rights of innocent third persons, the elections procured through fraud or undue influence, or of elections followed by the failure of the provision made in the will for the electing party, or the non-performance of a condition upon the election was made, has been widely recognized. I believe there's a condition. All of this applies. It all applies, okay? When we have to look at the 14th Amendment as a codicil. Next page, section 1639. In this paragraph, you are told that if by some slight chance, or even a big chance, you have taken property under the will, you have to return it in good faith. You got to return it. You have to offer to return it. But it's just proper to make a good faith offer to return it. This isn't everything. Okay, now we go section 1647 on page 700. The broad principle that one who receives a benefit, and Social Security is a benefit, so is unemployment, so are your schools. When you read the statute of charitable uses, you will find what your benefits are. I mean, it's schools, it's military, it's highways, it's everything. All these things are benefits, okay? And all these things are received under the 14th Amendment estate. The broad principle that one who receives a benefit under a will by which the testator attempts to dispose of property which belongs to the beneficiary, or in which the latter has some right, claim, or interest, must, whether or not the testator was aware of his own lack of complete ownership, elect between his right to accept the provisions in the will in his favor and his right to assert his independent paramount title. We're now asserting our independent paramount titles, which is recognized in many decisions, has received actual application in a wide variety of factual situations. Prominent among these may be mentioned the situation existing where a testamentary beneficiary is the obligee in an alleged contract of the testator to devise or bequeath property, where a device or legatee is also named as beneficiary. We can stop there. Contract, contract. Is this bringing in some commercial UCC stuff? Contract. Did we enter into a contract in the 14th Amendment to receive benefits? Now, there might be a possibility there. Yes, I think so. Yes. So therefore we become an obligee. Now we have a possibility of the UCC coming in, so we keep that right here. 1657. Estoppel. Estoppel means you are stopped. You are barred. Now, that means a little bit more than that, but just...
Which one?
Section 1657, page 712. Okay, here's where we're bringing in the bar to us getting to the estate. The broad doctrine that one who accepts benefits under a will is subject to certain exceptions and qualifications. Estoppel, to attack its validity and binding effect, is frequently recognized. You go into and you start talking about your rights and etc. under the 14th Amendment. You are estopped. You can't get to your rights. You have no rights. They are privileges. Your rights reside in the preamble. Okay, you have created an estoppel by taking under the will.
Light went on.
Oh, did we have a light bulb go on? Oh my God! Have any of you had light bulbs go on? Any of you have a like a flashlight going? Wow, I hope so. I hope so. That's what this is here for. Okay, claim and acceptance of money. Okay, what am I going to read here? The view is sometimes taken, for example, that an election to take under a will once made itself operates as an estoppel. Okay, again, estoppel. You elected under the Social Security. No wonder you can't get rid of your Social Security. Okay, all those little revocations and letters to the Social Security Department, and the Social Security Department's going, hey, no, man, your Social Security number. You can do anything you want, And you try to get rid of that Social Security number, and you feel like you can't, but, you keep trying. Well, you're stopped. You took under the will. But then, of course, we haven't attacked in this angle before. Okay, when I recently sent a nice little letter to the Social Security Department informing them of their restraint on alienation, bringing up trusts and estates. And I don't think anybody has discussed this with them before. So we're going to try a new angle here. And we're going to keep trying to get new angles until everybody understands what's going on in this country. Then we won't have to use any angles because we will have our power back. The United States, the people of the United States, the voting citizenry, are getting so angry that they're all claiming that they're going to get their country back. They have no country to get back. They have no inherent rights. I'm sorry. It's that simple. It's sad but true. Let's continue on. We're getting out of wills, and now we're going to go to descent and distribution, which is found in Amjur 2, or I found in Amjur 2D, 23, or 23 Amjur 2D. Section 2, it's page 756. Descent and distribution, section 2, second paragraph. In its strict technical sense, the word inherent means to take as an heir, at law, by descent. Within this meaning, personal property is not inheritable. Oh, there's a hole there. One who takes under a will does not inherit. You take under the 14th Amendment, you do not inherit. This is an inherent right. It says so right here under estates, wills. They all fall together. Here we have something about vested at birth. We have to get to understand what vested rights, inherent rights, inherited rights, these all come together. The United States people as a conglomerate have no inherent rights. They have no vested rights. Well, they have vested rights under the 14th Amendment, but no vested rights here. And we have to keep this very perfectly clear. Let's find the next beautiful paragraph. Now, you have to also remember, too, that the 14th Amendment was never legally ratified because the 11 southern states were kicked out of their legislators and replaced with military leaders. So that nullified the Constitution at that point, and everything since then is obliterated. It is not law. It might be law for an inferior state, but not for us. Actually, I guess we have no law. Oh, let's go to a sideways page. When I write now, I don't call myself a state citizen because I don't like that word anymore. When I look at the 14th Amendment and I know that the United States government has the authority to do whatever it wants in its corporate capacity to property that has been owned or is owned to and ceded to them or granted to them, I look at the 14th Amendment and I say, this looks like a grant to me. It looks like property ceded to me. As much as I don't like the idea that sovereign state citizenship has been ceded to the United States government, it may be a possibility. And if it is a possibility, what do I have left to discuss with them about where my rights come from? Well, I have my estate, and I also have the idea that I am an heir of freedom, as the Founding Fathers were. That's what they claimed themselves to be. They didn't claim themselves to be sovereign citizens. They didn't exist. The Crown gave that to us. So if sovereign state citizenship has been ceded to the United States, such as what we find under the Buck Act, okay, totally different subject, but it's also an interesting theory that the state has been ceded to the federal government. So now what do I discuss? Well, I discuss my heirness. You can call it, I am an heir, okay? And on this page here, I call myself an heiress astrarius, which is a common law word, and let's see if we can find it. Okay, down here there's 2 stars on the left, and it starts out with Coke shows. Okay. Coke shows the heir apparent may also be complete heir. That's me. And have use and profits of the estate. Yes, that's me. That's definitely me. He is termed the heiress astrarius, and he takes by descent. For if he took by purchase, he would be subject to relief, and I am definitely not subject to relief. I have no relief, so I must be the heiress astrarius. So therefore, I now sign my name, comma, sui juris heiress astrarius, because I'm also of age and I am competent. And this is the dawning of the age of Astrarius. This is, yes. Okay. I think they've already done that, except they really messed up the wording, so they probably couldn't read when they wrote the song or sang the song. Okay, now so far we have gone through the most important thing to understanding the preamble. Okay, the estates, the covenants, the things, and like I said, in your leisure, I mean, right here, I've just skimmed over this right here. You have plenty of material to read from what I have just given you, and there's more of it. Okay, now we're going to go into trusts, okay, because we're going to segue from our state over to the inferior estate. Okay, everything I read will still apply to this, but now we're going to start swinging over here to the 14th Amendment, and we're going to look at a different estate. Everything has been commingled up to now. Okay, the first we're going, oh, this is a marvelous book. It's called The Law of Trusts and Trustees. It is by two Bogarts. I don't see. Is one alive?
Yeah.
One is still alive.
Back east.
Oh my God, that's wonderful. Well, the original was, it must be his son, I guess.
They're brothers.
Brothers. I presume that they were sons. The original was written in 1931. Perfect timing. They had a lot of world of worth of information there. And it's basically upon normal, average, ordinary trusts. And every now and then they throw something in regarding history, government, etc. Okay. On page 4, section 1, he names they name the trust parties. Okay. There is a settler of a trust, and he is the person who intentionally causes it to come into existence. There we have the Founding Fathers. Okay. The trustee is the person who holds the property for the benefit of another. Okay. It's the government's duty to take care of our property for our benefit. The beneficiary or cestui trust is the person for whose benefit the trust property is held by the trustee. That's us. Well, I don't like to call that us. I like to call us the heir, because I don't want any confusion between their 14th Amendment beneficiary and me. So I'm an heir, because this shows that there are heirs in here. Posterity is an heir. There's, we go into the trusts and trust rights and duties, okay, and he defines for the benefit of the cestui, and we, cestui trust means beneficiary, and it goes into the duties of the trustees.
Where is this?
Oh, this is on page 6. This is superficial stuff that we're going through temporarily, okay? He goes into the classification of trusts, okay? On page 7, trusts are usually classified into two main groups, express trusts or implied trusts. We really don't want to get into the quagmire of federal law. Because it's just like quicksand. Quagmire, it's like quicksand. On page 264, remember we discussed the Catholic Church. Section 37, Religious Corporation Soul. Some slight remnants of the doctrine of corporation soul still exist in American law. In the English law, the king, certain church officials, and other occupants of public positions, were treated as having a separate entity as officials and were called corporation soul. The king, the sovereign. Could it possibly be that our corporate capacity of the United States government is a corporation soul? Yes. There's so much in Bogart that I have to search for it. I bought these books for $1 a piece. Let's buy that, and I thought I had a complete set, but number 4 was missing. So I think I paid $5 or $6 for the whole set of Bogart's Trust, and it sat on my shelves for almost 2 years. And I was about ready to give them away, going, well, I don't know why I'd ever used them. I wasn't interested in trusts, at least I didn't think so, until I found this, and then Bogart came up with some wonderful things. Okay, next page, 546. Oh, selection of trustee who cannot be sued. Let's go down to the marked line. It says, neither the Crown in England, the United States, nor a state can be sued without its consent. What? Now we have the trustees. Now I can show you that they're trustees, okay? They bring in the words, United States, Crown of England, a trustee who cannot be sued, okay? And the United States claims that they cannot be sued unless they give their consent. that's kind of, you can read that later. California statute preventing. Oh, here's over on the right-hand corner, bottom 547. A California statute prohibiting gifts by will to the United States among other corporations is not unconstitutional on the ground that it permits gifts to the state of California and its subdivisions, U.S. versus Bernison, 1950. Here we have a mention of the United States in its corporate capacity. Okay, so when, the question in my mind comes up quite often is just when did they start using their corporate capacity, because they weren't always a corporation. They didn't start out that way. The words don't say in God we incorporate. The words say in God we trust. Okay? So when do they start exercising their corporate capacity, and is it a de facto corporation or a de jure corporation? In the state of California, in most states, you cannot be a de facto corporation. I don't see evidence that they are de jure either, except for this grant right here. Page 556 is on reservations. It is common that the settler is himself a trustee, either by his own declaration or that fact, or by reason of a conveyance by himself to himself and others as trustees, or by buying land in his name as trustee for another. If the settler reserves no powers to himself expressly in the trust instrument, he will, as settler, have only sentimental interest in the administration of the trust. That is why there is a reservation in the Fifth Amendment and reserved to the people, so that there is no sentimental interest. The reservation, remember, is important. That I told you before, had to have a reservation. Isn't this beginning to look beautiful? Yeah. Got to keep those reservations. Everything falls into line under these estate laws. And hence his position as trustee does not, in the usual case, give him a dignity of legal interest. Duality? Thank you. Duality, yeah, my eyes are getting a little tired from reading. Page 557. Municipal corporations as trustees, in that it goes into the towns, cities, villages, school districts, and other governmental agencies are created by the state. Okay? Down at the bottom, when you see a little mark where I say cypress, cypre, okay? We're going to get into cypre. It's important. Are we missing a page? No, I guess not. Okay, we're going to go back here. Cypre, I'll see if I can. If such power is lacking, there will be vacancy in the trusteeship, and the court will appoint a trustee. This is cypre, okay? But the validity of the instrument of creation will not be questioned, okay? I know it's vague so far. In the groups of governmental, eleemosynary, or educational charitable trusts is on the next page. Got to find where we can clarify this. A municipal corporation has no power to accept and carry on a private trust or a charitable trust for religious purposes. You know, this is added quickly, for religious purposes. It didn't say or charitable trust, period. It says charitable trust for religious purposes. The 14th Amendment is a charitable trust. It establishes a...
That's why everything's in a private corporation.
Right.
Social Security.
Yeah, well, okay, the way I see it is the Federal Reserve Act created the trust fund, okay? It established the trust fund. It actually did establish even maybe a lesser estate than the 14th Amendment, a non-freehold estate. The Social Security Act itself created possibilities for beneficiaries to draw from the trust fund. Okay, the way I see it is the Federal Reserve Act created the trust fund. Okay, it is.
Okay, for all of y'all coming into my class, who created the trust fund? The Federal Reserve Act. Okay, you're dealing with the banks back then of all the blacks all around the Americas. Every city, every state, all of them. Silver and gold must be turned, all the good stuff. So this is that time. Okay, I know they bounce it, and you may feel like they're bouncing around times, but it's only 100 years ago.
Established the trust fund. It actually did establish even maybe a lesser estate than the
Okay.
14th Amendment.
Okay, so here it is. If you paying attention, okay, the Federal Reserve Bank is how America is funded today. This is the same power structure, the same octopus, same Leviathan power. Okay, this isn't some foreign nation. No, this is Canaan federal law mixed with a little banking and this one and that one. All of it is against the law. So I was right again. That's why I'm not dealing in the fantasy of it all. I'm going just straight to it. And if you're a student here, God bless you. God bless you. If you're a student here, because I'm trying to get to know all my students. So shout out to y'all.
A non-freehold estate. The Social Security Act itself created possibilities for beneficiaries to draw from the trust fund.
Boom. You get it? The Social Security Act. It's like when you go to jail, they can withdraw from the trust fund. This is why. Very important you understand that. Remember that your status is based upon the estate you are in possession of. Okay? Okay? This is some augmented reality shit. This is some get out shit. Your status, their status is based upon the estate they are in. Remember I told you it was multiple names. They're using your name. So each one of these duplicates status is based upon the estate you are in possession of, freehold. The life estate, such as created by the 14th Amendment, has been constantly diminished. Let's go.
That's where you separate the gold and silver from the Federal Reserve note.
See?
Now you're a beneficiary over here.
See? Say it again. She finna tell us how it's done. Right now. This is a strong point. Make sure y'all write this down.
That's where you separate the gold and silver from the Federal Reserve note. Now you're a beneficiary over here under your Mortmain principles.
Under your Mortmain principles.
Collecting money that is for the beneficiaries of the 14th.
Told you, because they're under your name, because it's like they're taking care of you. $5 Indianship. The whole government is built off of you.
Amendment, estate, and trust. So we're going to get into this further. I want to find C-Pray when I can. I wish I hadn't brought that up so soon. On page 560, in the early law, the position was taken that a corporation could not hold to uses or be a trustee on account of its impersonal, artificial character.
Told you. It's illegal. Let's continue on. But then how did the Federal Reserve create it?
It had no conscience. Equity could not act on it by a decree strictly.
It had no conscience, no soul. Wasn't real.
In personam. This objection was
a persona.
overcome as early as the middle of the 19th century. This is when they started to attack the Mortmain statutes. Okay? In modern times, corporate trustees are probably more common than individual trustees.
Told you.
Mm-hmm. And the trust company, the professional corporate trustee, assumes an ever larger position in trust management. Boy, it sure has.
Told you. That's what.
It is obvious
That's the corporation you serve.
that the charter or incorporation papers of a corporation, considered in the light of the statutes and constitution of a state, will determine the capacity of a corporation to administer as trust. Let's turn pages. Let's go on. The Law of Trustees and Trust by Bogert, again, Volume 2. Now we get into federal income tax, duty to make a return.
Where's it?
143, Section 264. Trustees are under a duty to make a return of income of the trust if its net income was $100 a year or over, or its gross income $600 a year or more, if the beneficiary is a non-resident alien. Footnote 39. Please go down to footnote 39, letter C. Do you see on the side there where I have written? This was valid in 1910. Any fiduciary required to make a return under this chapter shall be subject to all the provisions of law which apply to individuals. What law applied to individuals in 1910 with the duty to make a return? When was the 16th so-called amendment passed?
Damn.
No, 1914, wasn't it?
It was after 1910.
Ah. No, you're right. It was 1913. Yeah.
Well, it never was ratified, but supposedly 19.
Well, even if it was or if it wasn't, here we're discussing that individuals are supposed to have made a return prior to the supposed enactment of an individual income tax return.
Corporations.
This was for trusts. What they did was they created the laws that were going to apply to us before they applied it to us, and they applied it to the trusts that were in existence. They attacked the existing trust at that time in order to break them down so that it could eventually come around and be applied to us under what they've already established.
Devious.
Ah, the plot thickens. Yes. We go on. Okay, returns. If the return is made on the basis of the calendar year, it must be made by April 15th. The laws were already established before they created them toward us. Wasn't that generous of them? Here down here it says, if he makes oath that he has sufficient knowledge to the affairs of the trust to enable him to make the return, and that the return is correct to the best of his knowledge and belief. Here we have your statement of perjury. Now, trusts were attacked in court openly from what I gather from about 1893 to about 1925, even further on. They were attacked in order to destroy the integrity of our trust, to chip away at the building blocks, the foundation of this country, to get through to this. Now, on page 164, I don't know if any of you have ever received letters from the Internal Revenue Service or the Social Security Department saying that something about a right to receive. If you probably would skim right over it, okay? Everything's all about a right to receive. when they use the words right to receive, there is a trust involved. And on 164, there's a little line there is talking about the beneficiary has a right to receive. And so does page 165. If you ever see that wording in a letter that you receive, oh, they just informed you of a trust. They just informed you. They didn't use the word, but they just informed you. That's how they inform you deviously, okay? Under the table, underhand. Now, according to Bogert, on page 216, it starts, there was a case in 1925, Frick v. Commonwealth of Pennsylvania, and says in the decision in Frick v. Pennsylvania, it put an end to all this and placed property taxes and inheritance taxes on essentially the same basis, so far as the power to tax with reference to chattels were concerned. Now, I've read this court case, and I can't find it, but I believe truly that this man knows exactly what he talks about, and that inheritance taxes and property taxes were placed on the same basis and same level. Like I said, I've read the case, and I keep scratching my head going, now, how did they figure that one out? Obviously, it's got to be in there somehow and somewhere.
Probably the wording.
Oh, I'm pretty good at figuring out wording. But have you read it? You haven't read it? I've read it. And I take this man's word for it, because this gentleman or these gentlemen knew a tremendous amount, and they gave a tremendous amount of information on trust, and they evidently saw it. I believe it's there. I just haven't figured out exactly how it's worded in the Frick case to have property taxes and inheritance taxes placed on the same, essentially on the same basis. Okay, so now here we have the income tax and the presumably the inheritance tax going like this. We're now on the same basis. So this is how they brought all the trust stuff into our supposed income tax. Okay, do we get it? The couple paragraphs down, as will be shown later, the estates of aliens and non-resident citizens are to some extent subject to the federal estate tax. Some extent. We're still on the same page, 217. Okay, the last paragraph. The estates of aliens and non-resident citizens are to some extent subject to the federal estate tax. Now, what if you were a non-resident alien in this country? You know, a lot of people are attempting to use the non-resident alien argument, and you know, are you really a non-resident alien? Are you, what the heck are we? Are we really sovereign citizens? Are we heirs? You know, I'm an heir, but a lot of people are using the non-resident alien argument, and it may or may not be exactly what they think it is, because I have found different wording or a different way of writing or saying non-resident alien. And I don't think it means non-resident alien, but then I may be wrong. We'll be reading that shortly. I'll let you determine exactly what it means. News at 11. Gift tax, page 306. The federal gift tax was incorporated into the Revenue Act of 1924, but was eliminated in the revision of 1926. For 6 years, there was no such federal tax. But in 1932, this feature of the tax statute was reinstated. And it is to be found in the present statute in detail and elaborate form, having been amended from time to time between 1932 and 1951. Well, my gosh, they took it out for 6 years, from 1924 to 1932. This must be important. Okay, the gift tax stuff. Why would they have taken the gift tax stuff out for 6 years and then put it back in around about the time the Social Security Act came in? Does that seem to make a question arise in your mind? Gift tax taken out for 6 years? If it's an estate, if this is an estate and the 14th Amendment creates an estate, what is the income tax? Down at the bottom, let's see. The statute applies to gifts of property of all kinds, whether the gift is by trust or otherwise, and is direct or indirect. If the transfer is a citizen or resident alien, the act applies to transfers of any of his property. But if he is a non-resident alien, it governs only as to property situated within the United States. Couple bells go off? A bell go off? Any bell go off?
Try to be dinging.
A little ding, just a little ding? Did you catch a little word such as the words situated within the United States? Ever hear that before? The tax is not imposed on the recipient of the property by the donee. On the contrary, the tax is primary and personal. Liability of the donor is an excise upon his act of making the transfer, is measured by the value of the property passing from the donor. Any more bells go off? Of charitable trust. Now we're going to go into charitable trusts, folks. Okay, we just touched upon taxation as found under trusts. Okay, and it's bringing out little bells and little catch things, that keep getting your attention. Like, oh, what was that? Did you see that shadow flick by? Was it something truly there? Okay, we want to find out if these little shadows flicking by us are in our imagination or if they actually exist.
Can't wait to see when it says voluntary compliance.
Oh, it's voluntary.
Yeah.
Sure. Oh, it's voluntary. You volunteer to take under the will.
Yeah.
You made that election with voluntarily. Now, charitable trusts. Let's see. The preamble of the statute. We're on page 418 of Bogert's. The preamble of the statute of charitable uses gave illustrations of current charitable trust, but was not intended to set forth an exhaustive list of trust. Going further on, showing the kinds of objects in which the 17th century were regarded as social benefit, but surely could not reasonably be considered as a measure of 20th century social policies or purposes. Do you want to bet? Do you want to bet? Let's see. Oh, by the way, just to go off side, that the statute of uses, not charitable uses, I don't know about it, but the statute of uses in England was repealed in 1925. Great timing. Them and us. 1925 was repealed. This is a statute of 43 Elizabeth C4, made in 1601. Okay, now this is a long time before the revolution in our country. Here the founding fathers were, fighting for the Magna Carta. Now the Magna Carta was written in 1215. Here they were fighting for the Magna Carta in 1775, 1774, 200 odd years. Okay, here we are now 200 odd years again away, fighting for the same thing that they fought for 200 years ago, or wanting to fight. Not even pre-revolutionary war, if there's going to be one. Hopefully, it would be nice to have a civil understanding between the government and ourselves. But the jumps were, they did not forget the Magna Carta. And now I am not forgetting the Magna Carta, nor am I forgetting the estate and the preamble. So time comes down to just, the argument just happened yesterday, as far as I'm concerned, with the Founding Fathers and the Magna Carta in 1215. Everything was just like it was yesterday. To me, I've reduced time to a very short period of time. But the statute of uses, again, or the statute of charitable uses, relief of aged, isn't that Social Security? Do we say, okay, the relief of aged, impotent, and poor people, that is definitely, absolutely Social Security. Okay, if you can relate to something and it starts looking like it, it must be it. As far as I'm concerned, the statute of charitable uses is the English Social Security, form of Social Security. There may be a section somewhere around here where it shows that taxes in England are for charitable uses. Yes.
One of the other areas.
Did you happen to see it?
Yeah.
Okay, it's for houses of corrections. Okay, tradesmen. Here we could have employment. The redemption of prisoners. Here we have our prisons. The ease of any poor inhabitant. Here we have all our socialized benefits. Our socialism. Okay, comes from the Statute of Uses. So here we can look at the 14th Amendment and say it must involve a charitable use, a charitable trust. Yes, it does. Okay, let's pass on. Okay, if we look at the 14th Amendment is beginning to look like a charitable trust. It is. Now on page 451 we go into Mortmain. The English Mortmain and Charitable Uses Act. Oh my God, they just right in together. There's a little marked section in the footnote of that. It says a charitable trust may be created by will, by the incorporation, by reference into the will of the resolution, declaration, or trust agreement executed by a community trust if such instrument is recorded in the office of the Secretary of State. Okay, whatever happens in small trust happens in our trust, in big trusts, okay? Now, when we look at the 14th Amendment, we found here that we could not name the heir. The 14th Amendment names an heir. It names the heir. But it doesn't do it here, it does it over here. So here we have a separate estate that is lessened. We have a life estate that only is good for your life. It cannot pass on to an heir. And it is a trust. We're beginning to establish that it is a trust under the charitable uses. And let's try to skip on because I think I'm going to have to have a break shortly. I wanted to see if I could find Cypress. Now, under charitable trusts is where CIVILITER comes up. And what CIVILITER means is that somebody has the ability to change the trust. In England, the king could change the trust, or the Lord Chancellor. Okay? But the Lord Chancellor only had limited capability to change the trust. He couldn't do a lot. He could only do a little bit to a charitable trust or to any trust. The king had ultimate power. In the United States, the Congress did not have CIVILITER power. It was not given to them. It was not one of the prerogatives given from the Crown, and it is a prerogative. It's the parens patriae prerogative, meaning parens patriae, mother of the country. Okay, the state has parens patriae power. The states. And charitable trusts fall under the CIVILITER power, and I'm trying to find this.
You said that the government had no CIVILITER power?
The United States.
That boy Kev cold. Hit that like button and subscribe. Up before the sunrise. Quicker than the drug dealers. My choppers. Man, I'm slobbering at the mouth like I see steak and potatoes and eggs for breakfast with a couple pieces of toast. Press one. See, this a different mentality. This the mindset of sovereignty here, champion. No, bro, y'all can't fool me. No more, champ. That's it right there. If you didn't understand what she just said, you got to do another year in as a freshman. Oh yeah. Oh yeah, you got to want this information. Yeah, you got to want it. Like you want pairs of Jordan and you want anything else in this world. You got to want this. Damn. Everything I've been seeing is simplified. Now, this is she's speaking from different laws and different things, but You've been getting it here this whole time. Years and years and years and years and years of study. So much stress. So much nonsense. And this is what's important. It's that important. She put her best clothes on at a time to tell it.
And charitable trusts fall under the see, pray power, and I'm trying to find this.
Like I always say, you can't fool me by daydreaming. This is the only thing that matters. You can't pretend you leading me nowhere. You can't pretend you paying attention. Because this is operating on multiple understanding of multiple laws. There has to be questions by the men. There has to be questions. There must be, oh, well, that means there must be brain activity. There must be something. Let's continue on, because this is dealing with you.
The government has no see, pray power.
The United States government has no see, pray power. They exercised a power to that was resembled that. I'm trying to find it in the court case, the Mormon Church court case.
Boom.
In the latter part of last century. Bogert here says that the United States government did not have it, but they exercised something that resembled it in that particular case. He goes into governmental trust on page 162. Hopefully we'll oh, here we are on the next page. Yes, okay. Section 432 on page 321. Judicial and prerogative cypress powers. Sometimes I say cypre, sometimes I say cypress. In England, a distinction has been drawn between the cypress power, which is vested in the Court of Chancery and is exercisable by it usually through a master, and on the other hand, the cypress power vested in the Crown as a parens patriae, also known as the prerogative power, which is exercised by the sign manual, etc., at the suggestion of the Attorney General. The power of the court is almost always based on the existence of a charitable trust, okay, or of an absolute gift to a charitable organization. The royal power is exercised in several cases where there is a gift for charity without a trust. That's the royal power. Basically, what I'm trying to get at is when Congress applied the cypress power to the Mormon Church, or what appeared to be the cypress power, they took a power that they didn't have, the ability to change a trust.
Told you. That's why you believe in Christ the way that you do. Because you believe in Christ the way the Mormon space aliens believe in goddamn the Christ in Scripture. That's the world you live in. The United States had to go to them. I told y'all the Mormons did this. This is your understanding of accursed black people and zoom zooms and wham whams. I'm not going to get into it. But this is where the accursed of Ham and outer space and this one and that one, all this came into the picture. They're trying to understand it, but your allegory really took place in banking law, Canaanized form, maritime law. So you'll see the judgments of their God carried out in the early 1900s. Because they're the ones carrying that out.
Or create a trust. It applies to this, okay? The 14th Amendment was already in existence, but they didn't have the power to create a trust.
Told you.
So they snuck a little bit of it. Took it, the cypress power. They didn't have the power, only the states had it. So they, well, let's see if we can sneak it through here, and nobody will look and nobody will notice, and then we'll get some clear footing here and create the Federal Reserve Act, the trust, funds, and the Social Security Act, and whatever they were going to create in the future.
Boom.
Because they're at least 20 years in advance knowing.
So you went to prison. All this is going on. I had to research what was going on with us. The worst destruction and genocide the world has ever known during this time.
What they're going to do. Okay, page 332, the doctrine of Cyprus is a doctrine of prerogative. This comes straight from the crown. When the king signed the Treaty of Peace, he gave the states, the people of the estates, the prerogatives of the crown. Of course, Congress did get some, but not all. Cyprus is enforced in some states. In the states where Cyprus is not enforced, the failure of a charitable trust gives rise to a resulting trust for the settler or his successors. So we're talking about the creation, the manifestation of a trust. And Congress, on page 335, it shows you that 1890 was the Mormon Church incidents where the Supreme Court seems to have sanctioned the use by Congress of something like the prerogative Cyprus. Right there, they broke our trust. They created a second trust, or gave them the authority to do so.
Boom.
Okay, they took the authority illegally.
There you go.
By the Cyprus power, by exerting this power that they'd never had. Now, do you get the idea of what Cyprus means? Okay, you won't get it all at first because Cypress is like kind of scattered out there, and it's like a bee you're trying to grab a hold of. You kind of get it, but it's not really clear enough. And once you get that it's basically the power to change or create a trust, okay, then you're beginning to get it.
You're going to get it. Okay, now go back in history. Who is the trust busters? Okay. Who gave all of the gold and silver to J.P. Morgan? Let's continue on.
But they did not have that power. Okay?
That would be for charitable reasons.
For charitable purposes. They had no power. The king alone has the power, which is the people, the sovereign heirs. Okay? They alone had the people. The states had the parens patriae. That's why that welfare, state welfare, is the state's business. That's their parens patriae.
Told you. They take care of you.
Sovereign power. Okay, it's a charitable use, welfare, state welfare. Of course, it comes from the federal government, but they try to hide that. Moving right along. Oh my gosh, are we going to get through this? Okay. I feel like I'm rushing. Okay. We've hit trust. We've hit charitable trust. We're looking at the 14th Amendment as a charitable trust. Okay, or a trust, having charitable attributes. Next, we have a few ditties on guardian and ward. 39 Amjor, 2D, section or page 159. My, what is this? A trust relationship between guardian and ward? Is a 14th Amendment citizen a ward?
What page is that? 159?
Yeah.
159, section 208. Okay, it has been said that in no relation except perhaps that of parent and child or husband and wife are the elements of confidence on one side and active good faith on the other more essential than in the relation of guardian and ward. The ward is frequently a minor and often so young as to be entirely dependent on his guardian.
Not like this. Not like this.
The guardian is sometimes the ward's father or mother.
Both of them. They just described the mechanical mother, and the father is the governor, the state. Oh, you're in big trouble.
And if not, sustains a quasi-parental relation.
I can't
The
believe
government itself
This is the
is,
Matrix.
in a sense, the supreme guardian, whom the individual guardian represents in its solicitude for the welfare of the wards. Oh, what wards?
Oh, we genocided them. Which one? Oh, jeez, Louise. I'm CIVILITER MORTUS, remember?
Oh, you mean there must be specific words? I doubt it. Guardianship, therefore, has been said to be a trust of the highest and most sacred character. Now, believe it or not, they are a guardian up here. It is a trust of the most sacred and highest character. They are also a guardian down here, guardian-ward relationship in the 14th Amendment area.
As above,
Okay?
so below.
Different effect and different rules.
Told
and
you
different...
we operating in different laws. Told you. If you haven't been paying attention and you cannot speak, you cannot make the jump. You're going to have to try again next year. I'm sorry. You go as it caught up in fantasy world and the science of that thereof, and you want to pretend you understand science without understanding this, you playing. This is your power here. Your understanding of these laws is how you become free. I now know what it's like to be playing around, goofing off, and entertaining it. But now that KevRow no longer university. Oh no, I didn't wake up at 3-4 this morning to play around and for me to pretend, our students to pretend. This is important for everybody to understand. And you have to, because there has to be, like King Bear, who are you? You have to pretend. You have to participate. You have to express yourself to show. But you don't even got the books. King Bear, you got to get the books, champion. I'm saying this over every 3-4 months. You got to get the books, y'all. I'm almost begging you to do better. I'm almost begging the fellas, hey, we got to, because I'm doing my work. Yep. I get up here and teach. I'm doing my work. We got to understand it at the trust level, the state level, a state law, Black's law. You got a lot of law to get to.
Principles, but they are still a guardian of our covenants and trusts and everything up here in the preamble of the highest character. This is parens patriae, okay? As you notice on the side, it defines actually parens patriae. Now, down at the bottom, you notice that the confidential relationship immediately arises between a person-appointed guardian and his ward for the benefit of the ward upon the guardian's taking his oath, executing the required bond, entering on the discharge of his duties, and receiving as guardian property, money, or effects of his ward. These people have taken oaths. They have bonds. They have entered upon the duties. They are guardians. It is a trust. And when we get right down to it, these oaths, the oath is where God lies, and the bond is what needs to be attacked. Okay, next page, page 26. What they're discussing here are wards being infants or other incompetents. The heirs of the preamble estate are neither incompetents nor are they infants. They were sui juris and in their majority, meaning that they were of age 21 years old, they were citizens and therefore could vote. 14th Amendment citizen, on the other hand, is either or an infant or incompetent. That is what the 14th Amendment Amendment was created for. Infants or incompetents. Okay, continue on. Here we have things on infants and incompetence, protection and custody. Now we get into the parens patriae, which is attached to Cypress. The state, through its proper organs, exercises its power for the protection of infants, since, page 20, since it, as parens patriae, is the guardian of the children within its jurisdiction. The federal government, however, does not stand in the position of parens patriae with reference to the persons and property of infants, except in the territories and the District of Columbia. The United States government does not have parens patriae power. The states have parens patriae. Oh, except in the District of Columbia and the territories. At this point now, yes, it is the states as defined under the Buck Act. Okay. But the states as defined under the Buck Act, which is found in Title IV. Okay. Once they statutorily define something, they change it. For example, employment has been statutorily defined under the Social Security Act. It is no longer the employment that we know it as here. Okay, it is owned, possessed, or ceded to. Once something is statutorily defined, the United States now owns it, or it has been ceded to it, is now fall within the corporate Mort-Main capacity. Boy, they've really shredded this country apart, haven't they?
Ye old shredder.
This poor woman here looks like she's about ready to cry or like, oh no, I didn't know all this.
Yeah, that's what happened.
It gets overwhelming. You know, what they've done looks overwhelming, and we really must try to we know what they've done. Now we know really what they've done. You know, it's we're down to the nitty-gritty here. Again, on page 21, they bring into the discussion parens patriae. The state as parens patriae is authorized to legislate for the protection of care for the care of children under its jurisdiction. Now, when we're talking about infants, okay, we're also bringing in the incompetent people, okay, because they all fall in the same hat. Okay, infants and incompetents fall in the same hat. So this applies to them. Now, when you're an infant, let's see, the jurisdiction of equity over persons of property originated in the it originated in the prerogative of the Crown of England, okay, arising from its general duty as parens patriae to protect persons who have no other rightful protector. Oh, God, I don't know if I have another rightful protector. This goes into heavily what parens patriae is. Now, on the next page, on page 66 in section 65, you will see something that says liability for necessaries. This is a principle applied to the Social Security Act and your income tax and et cetera, et cetera. It is well established that an infant is liable for the value of necessaries furnished to him. If you're an infant or an incompetent, you're liable for the necessaries furnished to you. An infant's liability for necessaries is based not upon his actual contract to pay for them, but upon a contract implied by law. Have all you people been asking for the contract? You know, where's the contract that I signed that said I have to do this? It's right here. Because it is presumed that you were being supplied the necessaries of life to take care of an infant or an incompetent. Or in other words, a quasi-contract. Thus, an infant is liable for the value of necessaries if they are furnished to him under such circumstances that a promise to pay for them can be inferred. And he is likewise liable for necessaries furnished to supply his urgent need, even though he is too young to understand the contract for such necessaries. Next page, 67. The rule that an infant is liable for necessaries furnished to him was incorporated into Section 2 of the Uniform Sales Act, which provided that where necessaries are sold and delivered to an infant, he must pay a reasonable price for, although the comparable provision in the Uniform Commercial Code, while the UCC comes up, simply provide in part that unless displaced by the particular provisions of such code, the principles of law and equity and the law relating to capacity contract, etc., 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 he's bound by his contract. Right here is where you get the contract that the Social Security is upholding against you because you're an incompetent or an infant obtaining its necessaries. You will also find that in the next one under incompetent persons. An incompetent may become liable by way of contract implied in law for necessaries provided to his dependents or to himself. Next page, what are necessaries? The determination of what articles furnish an insane person, oh my gracious, our necessaries depends not merely on their nature but also on whether they are proper and suitable according to the circumstances and his condition of life. The term is not restricted to articles that are basically essential to existence, but includes all articles and services proper for the normal maintenance of the incompetent. The wants or needs of an insane or other incompetent person, which are personal to body and mind, are necessaries. Here you have all the necessaries in life being provided to you by the Social Security Department in a social welfare state. Do you see it? Do you see the necessaries being that everything now can be construed as a necessary being provided to you as an incompetent person? Under this estate, are the building blocks building up from this coming down? Yeah. We also mentioned how a trust is terminated. There's no one inflexible mode for termination of the trust. We are all terminating this trust. Mm-hmm. When you apply for that Social Security number, you terminate this trust. You repudiate it. When you send in that 1040 every year, you repudiate the Constitution itself. That driver's license, everything the laws have been set up to do, force you to repudiate the trust. Now on page 388, we're going to go into spendthrift trust and similar protective trust. Now, the Federal Reserve Act, I tried to find the tape, somebody way back when the Federal Reserve Act was passed, some prominent person said that this creates the largest trust ever known on the face of this world, or earth, or something to that effect, and I couldn't find the tape as to who said it. Oh, it was you. It was in your tape then.
Probably.
'Cause it was,
McFadden? Yeah.
okay, that creates the trust. Okay, the 14th Amendment per se did not. It created a life estate which diminished this estate. Now, in my perception, the Federal Reserve Act, in conjunction with the Social Security Act, diminished the estate one more time. And I perceive it a possibility to be a lesser estate and one that is not a freehold estate. Even the 14th Amendment is a freehold estate, but it is a life estate. Okay? So now the estates are becoming diminished and more restriction is being placed on us, and we're going back into feudal times and servitudes and serfdoms and slaveries as the estate is being diminished, because that is the only way it can go. it is going in that direction. It already has. And we're going to get into the spendthrift trust here because the 14th Amendment, the Federal Reserve Act under the 14th Amendment created a spendthrift trust for incompetents and infants who were wards. Okay?